Welcome to Employment Lawyers in London, owned and managed by R.T. Cooper's Solicitors. This video is designed to give you a step-by-step guide to the terms of your compromise agreement, what to expect in a compromise agreement. Firstly, a compromise agreement constitutes a final agreement between you and your employer. What is a termination date? The termination date is the last day of your employment, and this should be included in your compromise agreement. Now, what about payment from your employer? You will be paid your normal salary and any accrued untaken holidays up to the termination date, as well as any expenses. You'll be reimbursed by your employer, provided you have expenses, of course. Now, you may receive a mixture of statutory redundancy pay, payment in lieu of notice, and there would be deduction for PAYE, and or an ex gratia payment, which would be up to the discretion of your employer. Now, payment can take anything from 14 to 60 days once both parties have signed a compromise agreement. All of your existing benefits will cease on the termination date, which would include your pension rights. In terms of legal costs, your employer would usually make a contribution towards your legal costs unless you have not agreed the terms with your employer, and you would require us, for instance, to negotiate on your behalf or to provide you with some additional advice above and beyond what would be covered by your employer's contribution. We would always tell you upfront what the cost is, so you would be able to agree whether you're happy for us to advise you in addition to the terms of the compromise agreement that your employer is covering. Now, in terms of taxation, any ex gratia payment will be tax-free up to a maximum of £30,000. So any redundancy payment that you receive would be tax-free up to that amount. Over that amount, you'll be required to pay tax. If you have any computers, laptops, or mobile phones, any property belonging to your employer would have to be returned, usually by the termination date. You will be required to give certain warranties to your employer, which are really promises that you would do certain things or you will not do certain things. One of the warranties is that you are not aware of any matters which would or might reasonably affect your employer's decision to enter into the compromise agreement. Another warranty is that you have not brought a claim, and if you have, that you would withdraw the claim in the employment tribunal against your employer, for instance. Now, you have to remember that your employer is not under any obligation to make the payments to you if you are in breach of warranties. So just remember that. One of the other warranties that you'll be required to give is that you will keep the terms of the compromise agreement strictly confidential, as well as the existence of the compromise agreement. Now, you may disclose to your lawyer, spouse, or next of kin, but you have to keep this compromise agreement strictly confidential, and this is crucial, and you must remember this. You'll also have to give a warranty that you've received advice from a lawyer, and the lawyer, if that's us, we would sign the advisor certificate, which would normally be at the end of the compromise agreement. Now, once you've received advice and you've signed the compromise agreement and your employer signs it, this then becomes a binding contract between you and your employer in full and final settlement of any claim that you may have against your employer. If you've negotiated a reference, then that reference would also be included at the end of your compromise agreement. Now, who we are R.T. Cooper's solicitors, a firm of solicitors, and we advise on employment law. If you wanted us to give you assistance with your compromise agreement, then contact us at inquiries@rtcoopersolicitors.com. We also have legal updates on our employment page of our home website, which is rtcoopers.com, or you can get some more information on this website, which is employmentlawyersinlondon.com. Thank you.